So, first of all, thank you very much for the invitation. It's a pleasure to be in Budapest, always. So, I've been asked to explain to you what are the fundamental differences and also similarities between competition law enforcement and the DMA. So I'll start with a few points, but really it would be nice to have a dialogue about those questions later on. So, first of all, I mean, what is the DMA like? The DNA of the DMA is clearly competition law. The DMA is a sui generis competition law statute. That's what it is. It is competition law. I mean, the Commission says it's not competition law, it's regulation, but in reality it is competition law. It would be a mistake to close our eyes to the reality. The objectives of the DMA are two. The first objective is fairness, and the other objective is contestability. Both of these two objectives are also in the area of competition law. They are very present in the area of competition law. Fairness is mentioned in Article 102A of the treaty, and contestability is, by definition, a concept of competition law, you know, contestable markets, there are theories in the US, etc., etc. So nothing really foreign to competition law. The substantive rules of the DMA, and I'm talking here about the prohibitions and the obligations in Articles 5, 6, and 7 of the DMA. These are the substantive rules. They are all inspired by competition law cases. Some of these cases are actually investigations. We don't have final decisions in some of these cases, although for some of them, like in the case of Google Shopping, Google Android, now there are final court decisions which confirm the Commission's approach. So some of these cases are Commission cases, others are National Competition Authority case. For example, if I remember well, 5 paragraph 2, which is about data, using data from different services, etc., the role of end users in giving, in opting in for their data to be used. This comes from the Bundeskartellamt's investigation against Facebook. Also, the public enforcement procedural framework, if you read all the second part of the DMA, which is about the powers of the European Commission, this is a copy-paste of Regulation 1/2003. It's clear that this is essentially, these are the powers that the Commission has in competition law enforcement. Private enforcement is also possible, like you have in the competition law area, again, very similar to the competition rules, and also the jurisdictional rules are, I would say, inspired also by the jurisdictional rules we have in the area of competition law, both with regard to public and private enforcement. Esther mentioned before the specific provisions on cooperation, exchange of information, duties to respect the authority of the Commission when taking certain decisions, etc., etc. These are all copy-paste of specific provisions in Regulation 1/2003, like Article 11, Article 15, 16, etc. So these are fundamental similarities, but there are differences also. What are these differences in my view? The first basic difference is that the DMA is based on a system of prohibition, whereas Article 102 in particular, which is the relevant provision for the DMA, is based on a system of control of abuse. This is a fundamental distinction that we tend to forget when it comes to the competition rules. Even within competition law, there's a distinction between Article 101, where we have the system of prohibition, and Article 102, where we have the system of control of abuse. So the DMA is like Article 101 in that respect. It's a system of prohibition. It's not based on analysis, for example, whether there has been an abuse of a certain concept, like, for example, in Article 102, when like, for example, there's no provision on abuse of gatekeeper power or something like that. You have specific obligations and specific prohibitions like Article 101. Second basic difference is that the DMA is based on, is essentially a clausus numerus of very prescriptive rules. So there are specific rules, and this is an exhaustive list. That's it. Very different from the competition law rules, Article 101 and 102, which are based on general clauses. Article 102 is a general clause. You cannot abuse your dominant position. Of course, there is a kind of group of examples in Article 102, but these are examples. It's not an exhaustive list, it's just an indicative list, and in fact, the courts never really refer to A, B, C, D, in 102, they don't really care about that. So, very important difference. General clauses in competition law and prescriptive rules, a list of prescriptive rules, which is an exhaustive list. By the way, the Section 19A is somewhere in between. In my view, it's closer to the general clause system because you have 7 prohibitions there, which, however, are general clauses because there is an in particular. So it's not like a closed prescriptive rule, kind of exhaustive list like you have in the DMA. It's closer to 102. The third important difference is that the DMA is based on a number of per se rules. These are per se prohibitions, per se, let's say, duties. There is no effects-based approach. There is no effects-based analysis. You don't need to prove any effects. You cannot actually rely on objective justification, efficiencies. There is nothing about that. These are per se prohibitions, unlike, again, Article 101 and 102. Article 101 has paragraph 3, and also other doctrines like ancillary restraints, etc. Article 102 also provides for the possibility to have an objective justification or to have efficiencies. That's, forget it. That you don't have it in the DMA. You do have it in Section 19A. Section 19A it is possible to put forward efficiency defenses. And finally, very important, the DMA, when it comes to substance, the DMA amounts to a system which is about ex ante obligations. It works on an ex ante basis. It affects the legal reality and the conduct of companies ex ante, whereas the competition rules affect the conduct of companies ex post. I'm talking, of course, about Articles 101 and 102. Merger regulation is also ex ante, but that's a different story. Also, in terms of procedure, some differences that we have here is that we talked about that already in the DMA. When it comes to public enforcement, we have centralized enforcement. It's the European Commission which takes the main decisions. All the decision-making powers are with the European Commission. When it comes to EU competition law, we have decentralized enforcement. We have national competition authorities which are also enforcing the rules in a decisive way. Here we will have 2 DGs being in charge, DG Competition and DG Connect. There will be like 40 officials in DG Competition and around 40 officials in DG Connect. And my understanding is that they have already, or they are currently, dividing also the tasks in terms of the specific prohibitions and obligations that each of these DGs will be dealing with. For example, prohibitions that are about FRAND terms, fair, reasonable, non-discriminatory terms, and data will probably be dealt with by DG Connect. When it comes to other prohibitions or obligations like the avoidance of self-preferencing, these are more likely to be dealt with by DG Comp. Another basic difference, and this is a difference of, if you want, of philosophy, is that the DMA is more, let's say, collaborative, I would say, in spirit. At least now at the beginning, it's based really on the cooperation between gatekeepers and the Commission. There is currently a pre-notification stage. There will be a notification stage, but also I think the aim also on the part of the Commission is to cooperate with the gatekeepers going forward and to have a dialogue, and essentially accidents, of course, will happen, I'm sure, and there will be for sure litigation, but the idea is really to have this, what Jean Tirole, the Nobel Prize winner, called collaborative or participative antitrust. You know, you speak with them, and of course, you know, by speaking with them, you adjust also even the rules, you know, maybe in the future, because as we have seen, the DMA is future-proof. That is the philosophy that certainly I see more in the DMA, although accidents will happen, as I said, there will be litigation. When it comes to competition law enforcement, it doesn't work like that. Competition law enforcement is more adversarial. You know, it's ex post, obviously, and you know, when there is an investigation, it's a much more adversarial situation. It's not so much about cooperating. Cooperation you may have when it comes to settlements or commitments decisions, but in reality, it starts in a very adversarial way. Finally, the DMA most of the decisions of the Commission when it comes to the DMA, except for non-compliance decisions imposing fines, are not quasi-criminal in nature. Don't forget about that. So the designation decisions, this is not about quasi-criminal decisions. So the guarantees that we are aware of when it comes to competition law enforcement, etc., no, they don't apply. Designation decisions, for example, or even specification decisions, or even non-compliance decisions where you have only the imposition of a remedy. Whereas when it comes to Articles 101 and 102, these are clearly quasi-criminal. So what are the opportunities and what are the risks? There are some positive and negative elements, in my view. You know, first of all, the fact that we have a regulation dealing with these perceived problems, you know, these are problems that neutrally the public or the newspapers or, you know, the enforcer generally think that are important problems, and therefore, you know, the legislator has decided to act. Personally, I prefer that we have a regulation instead of completely deforming competition law to deal with the perceived problems. You know, I'm as a competition lawyer and as somebody who is really in favor of the more orthodox way of seeing competition law, I prefer to have this outside my area of competition law, because otherwise you end up with debatable and controversial theories of harm. You are doing things essentially that may harm in terms of the consistency of the system of competition law enforcement. So that I prefer, to be honest, instead of having to necessarily do something under the competition rules. The DMA also is speedier, of course, per force. If you have a regulation which applies ex ante, you know, it has already intervened in a way, so you don't need to wait for the competition authority to take a decision. It provides legal certainty. Of course, if you have like 20 prescriptive rules, thou shalt not, by 20, this is legal certainty. Per se, is always good for legal certainty. Of course, we'll come to, there's the other negative side, of course, but it offers legal certainty, clearly, and certainly also in terms of effectiveness. Plus, I like this focus on compliance rather than on enforcement, and in fact, I'm saying that because I see a lot of articles written also in the press, you know. Esther also mentioned that we don't have the resources, how can we be dealing, etc. Listen. Don't think of the DMA like you think in terms of competition law enforcement. Andras knows, in May every year, all competition authorities are wary to see where the global competition review will put them in the list of the stars, you know. So the Greek competition authority, oh, wow, 25 Don raids this year, 5 stars. How many fines have you imposed? 100 million. That's good. How many decisions did you take? This is not how the DMA should be working. If we start looking at the DMA in this respect, that's the failure of the DMA. Because if you have that degree of enforcement for the DMA, it means that the DMA has failed. The DMA is not competition law enforcement. The DMA is regulation. If you have compliance measures and if you have statistics like the ones I mentioned, it will mean that it has failed. So stop thinking in terms of enforcement with the DMA. DMA is regulation. Of course, there will be accidents, there will be cases for sure, but we should stop thinking in terms of statistics. Finally, some negatives. Per se means inflexibility. You know, it's good for legal certainty. The best legal certainty that you can have is with either per se rules of prohibition or with per se rules of permission. Anything in between, effects-based economic analysis, etc., that's not good for legal certainty, but it's flexible. This is the other side of the coin. There is a lot of inflexibility, crystallization of market structures and practices. It's, yeah, sure, they say it's future-proof. Good luck. I mean, when you prepare new rules and adopt new prohibitions, etc. I fear also that courts and competition authorities, so be careful, Andros, might read the DMA as if the DMA represented a golden standard for competition law, and there may be spillover effects into competition law enforcement. We should not be doing that. The DMA is something very specific. So do not use the DMA as a kind of inspirational guide for competition law enforcement. Don't do what the Court of Justice has suggested we should be doing in Slovak Telecom in other cases. There is regulation. Maybe it offers us some context in applying Articles 101 and 102. We should not be doing that. The DMA is very specific. It's about specific gatekeepers and specific core platform services. This is not general competition law. The fact that you have these prohibitions mean nothing for Article 101 and 102 in particular. Finally, fragmentation has not been averted. I fear that we may have fragmentation in Europe. Germany is the main risk. And finally, don't forget about the international sphere. There is a problem internationally. I mean, if already various jurisdictions have started adopting rules, I was reading this morning that Australia now wants to introduce specific merger thresholds just for big tech, etc. There is a problem in terms that we may end up with legal chaos internationally. Various jurisdictions adopting different types of regulations, etc. We need more international cooperation, and that's the topic for a new conference that we should have. I'll stop here, and then we can have a discussion later. Thank you.